Hey legal team, welcome once again to Fitz in Law School. I'm Fitz, and today we're going to be kind of getting back to the normal stuff when it comes to Fitz in Law School. We're going to be talking about what I'm doing in law school. So, I mentioned last week that I'm probably going to be talking about my briefs, and lo and behold, I am going to be talking about my briefs, okay? So, right now, this semester, I'm essentially in two different situations that require me to write two briefs, and then afterwards, I'm going to do two oral arguments. In each one of these situations, one is for my appellate advocacy class and one's for my moot court competition. I'm going to be taking on, there's two issues on each one. I'm going to be taking one of them myself. In my app ad class, my partner is going to be handling the other issue, and then in my moot court team, two of my partners are going to be handling the first issue, and then I'm going to be handling the second one. So, like in most of these situations, the brief is followed by an oral argument. So essentially what that is you get up before a panel who are acting like judges, and then they ask you questions about that situation, about the issue that essentially you're arguing for. In the moot court competition, I'm going to be going back and forth, doing both sides. So that's going to be just a long, arduous, and very complex process where I'm going to have to really, really understand the ins and outs of the case completely. And that's going to be a lot of work. But right now, we're only focusing on the briefs for both these classes, or the class and the competition. So let's just dive into it. So I thought that I would first cover the app ad situation. So what I'm going to do is I'm going to tell you about the facts, and then I'm going to tell you the legal questions that are posed before the court, and then I'm going to tell you a little bit more about my issue, which is the second one for both of these. First of all, the facts of my appellate advocacy thing. So what happened in this case is police came to an apartment building. In that apartment building, they found the front door, was completely unlocked. Not only was it unlocked, it actually couldn't be locked. So essentially anyone could walk in and out. The police came to that apartment building because they were going on a tip, just an anonymous tip, that someone in the apartment building was going and selling drugs, and they had a specific room number. And so what they did is they went and they took a drug sniffing dog, and then they walked through the hallways of each floor of the building, and the dog sniffed each one of the doors. And then when it got to, in this case, the defendant, his name is Derek Bonilla, and this is a real case. This is actually a real case that's happening and currently pending before the Supreme Court about whether or not they're going to take it. But Bonilla went and apparently was selling drugs in his apartment. And so the dog, when the police came to the door, the dog indicated there was drugs in the apartment. So keep in mind, though, that the police didn't have a warrant. And so the police then took this information, left, went and got a warrant, came back, arrested him. And so that's the situation. That's what happened here. And so the two legal questions that are kind of presented here is, number one, is a hallway curtilage? And number two, even if it is, even if it isn't, whatever, does the good faith exception apply? So in order to understand this, there requires a little bit of explanation. So first of all, curtilage. All right, so curtilage is essentially like this kind of, it started off as kind of a property rights based thing, and it expanded into like kind of a privacy thing in general. And so essentially what that is it's things that are kind of, well, all right, so let's start with the property-based approach of what curtilage is. Curtilage is kind of like that area that's connected to the home that you essentially like have kind of a expectation of privacy. It's like where intimate things are happening within the home. So think of it like your fenced-in backyard or your porch. Like a lot of the things are just like literally in the Supreme Court cases, they're a classic exemplar of curtilage. And so what that means is that there's a heightened level of scrutiny and stuff that takes place when you're in curtilage. So a very, very dispositive case in this issue is Florida v. Jardines. And essentially it's a cop going up, performing a drug sniffing dog, performing a search on someone's porch of their home. And the Supreme Court said, nope, not allowed because the porch is curtilage. And so it's classic curtilage and all that stuff. And so you can't perform a search within curtilage unless you have a warrant. And so it's essentially something that's kind of treated just like the home. You can't search someone's home without a warrant. And then there are kind of varying levels of what's kind of considered like curtilage or something. So So like the home is, or what's considered like kind of protected space. And so the home is the first one, and then it goes curtilage, and then it goes like an open field kind of a thing that kind of is attached to property, but kind of not. And then it goes public places where you don't really have that many expectations to privacy. And they're not really protected in that way. The second analysis of what curtilage could possibly be is a privacy-based analysis. So essentially what that means is, does a person have a reasonable expectation to privacy within a certain area? So, like for example, in one case that's being used in these general briefs is the idea that if a person goes and like has a space that they can secure, that they can like prevent the rest of the world from being in that space. Like for example, say you have like a common area hallway, like I do. I have a common area hallway. However, like my dad also has a common area hallway, but also in the apartment, he also has a secondary area that the public can walk around, but that he can go and lock and secure so that only he can go in there. So that would kind of be considered curtilage, because that is a place that is kind of exclusive to him. He can deny the rest of the world from going and entering that space. So that's kind of considered curtilage. However, the public area, like the public area hallway surrounding that, if it's not locked, like in the front door, maybe that won't be considered curtilage, that kind of thing. So the idea here kind of revolves around the fact that the public have access to this apartment building. If it's not locked, and if no one can get in and all that stuff, then like what? Is that curtilage? Is that not curtilage? What does it really depend on? And so me and my partner are arguing for the state of Illinois. So that means that we're arguing that this is not curtilage, and he doesn't have expectation of privacy and all that kind of a thing. So that's what we're arguing. The second thing also takes a little bit of explanation. The second legal question. That second legal question is, does the good faith exception apply? Now, this is totally separate from curtilage in that, say we lose on, nope, it is curtilage, so you guys lose, so that was a search, so you can't do that. This is totally independent of that. So that essentially means that the good faith exception can still apply, and we could still win, even if it still is curtilage. So the good faith exception is an exception to an exception. Okay, it's an exception to an exclusion. So what that means is, when you're searching things, when you're cops and you're searching stuff, there's sometimes it happens, and whether this is mistake or literally like misconduct, like they say, no, I don't want this, I don't like this guy, so I'm going to get him purposefully in trouble. Police officers and investigators and all that stuff, they offer evidence to a court. However, if that evidence was seized in violation of the Fourth Amendment, then you can't offer it in court. And so that's the exemption. That's like exempted evidence. So if it was improperly seized, or if they broke the law doing it or something like that, then you can't offer that in court. However, there's an exception to that rule, and that's called the good faith exception. So the exemption, so try to keep those straight, exemption and exception. So the exemption was created in order to deter police conduct. Okay, it was not to like punish careless mistakes, or it was not like any kind of thing like that. What it was designed to do is it was designed to make sure that police don't do the wrong thing. They don't plant evidence. They don't do all this kind of stuff. Because if you can prove that it was planted or that they was seized improperly, then that evidence won't be introduced. And sometimes that will result in, like, the court has acknowledged this, and this is a court-created thing, a court-created rule, is that the courts acknowledge that maybe sometimes that makes guilty people go free. But again, if the police can't do their job properly, then people shouldn't suffer for it, because you have a presumed innocence until you're guilty in court cases. So the good faith exception is essentially kind of a forgiveness measure a little bit when it comes to cops. And so that means that cops, if they have a good faith belief that what they're doing is the law, is based on precedent and all that stuff, and they think that they're completely following the law and stuff, then that allows evidence that was improperly seized to actually be introduced in court. So that's, I don't know. I mean, I'm not sure how I feel about that, really. I get that, we shouldn't allow guilty people to go free on a technicality, but I don't know. I mean, I just, for some reason, I don't really like that. Like, for example, like a normal person, if you're ignorant of the law, that doesn't matter. Sorry. Like, you broke the law, so you're done. You're in jail, you're whatever. I feel like for some reason we should hold cops to a higher standard than that. But at the same time, the more research I've done, the more I've kind of seen that, like, oh yeah, like I get that maybe I don't like it, but I get how it might be necessary, because like these cases are super super complicated, and so yes, while like the city kind of goes and advises police officers and stuff, it's clear demonstration that if the law was clean cut, there'd be no need for lawyers, there'd be no need for judges or anything like that. All we'd have to do is say, yep, you broke the law, so you're done. The law is complicated, and we shouldn't really expect police officers to be like lawyers and do kind of an in-depth analysis of that. That being said, though, I still don't really like it, but whatever. So I'm going to be going and arguing for the fact that the police officer did in fact have a reasonable, good faith belief based on binding appellate precedent that what they did was totally legal. And so how I'm going to do that is really, really point to the cases that support me, and then the ones that don't support me, try and differentiate them. Say that, like, yeah, sure, the respondent might say, or the petitioner might say the respondent might say that, oh, this case supports them and all that stuff. Well, no, that's not true. It's completely different, and kind of separate those two. And so that's where oral argument comes in, and that's really fun. So that's my first brief. That's my appellate advocacy brief. And that one, yeah, we're almost done. We're basically in the exact same situation with both of these briefs, me and my partners in both cases. So right now we're like combining all our things and really polishing everything and really making sure that it's all good. So that's my first brief. My second brief is for my moot court competition, and that's essentially where the facts of that case are: there's this guy, his name is Holland. That's his last name. I can't remember his first name right now, but his name is Holland, and he is a gay man who's living in a fictional place that is made up for the competition. But essentially, he's a gay man who is he got married under the local statute, and then from there he went and him and his partner got divorced. So while him and his partner were getting divorced, he went and applied to adopt a child. He went through the whole process. He did everything all perfectly and stuff. And then one thing that is involved with that application process is that a person who works for the local adoption agency has to come and kind of walk through their apartment and observe them in their life and all that stuff. And so there are 3 that are required. At the last one, the adoption agency person said, hey, Holland, you're doing great. It really, really seems like you have a great life and stuff. And so you're probably going to be able to adopt a kid. It's not finalized yet, but you're probably going to be able to adopt a kid. He's like, fantastic, great, can't wait, all that stuff. Then a couple days later, he gets a letter from the agency saying, nope, sorry, you're denied. And the reason you're denied is because we have found some salacious behavior that fits with some other red flags that we found in your past. And so Holland says, what the hell, man? That's not cool. What happened? What happened? And the letter says, yep, you can apply in another 3 years or 5 years or something like that. And so Holland is totally confused and saying, what the hell happened? And then an anonymous person from the agency goes and reaches out to him via email and says, hey, Holland, I just want to let you know that your ex-partner went and called us and said that you were doing salacious sexual activity. And I think what he said was he's having sex with prostitutes and all that stuff. And so because of that, he is an immoral character and he shouldn't be able to adopt a kid and all that stuff. And so it seems like based on that, the adoption agency said, yes, this coincided with other red flags in your past. That's what they said in the letter. So that means that it could be an excuse. It could not be an excuse. It could be something like that. But that's not the end of the story. So his partner went and gave these kind of unsubstantiated kind of things, and in the record, there's absolutely no proof that that's real at all. And then a couple days later, the head of the agency, the director of the agency, went on to a radio show. And so by the transcript that we have and all this stuff, it seems very, very clear that this is kind of a conservative radio talk show host, classic kind of a thing. And the conservative radio talk show host is talking about how the agency is giving away kids to gay parents, and gay parents are bad for kids and all that stuff. And so the director is on there essentially defending their conduct. But what she says upon kind of, examination from the radio show host is that she says that she says two things that are important. The first thing she says is that it's not a gay or straight issue. What it is it is a man versus woman issue. So what it is she first defends herself saying we're not giving away kids to gay people, just because willy-nilly. And then she uses an example without explicitly mentioning Holland's name, but she does give just enough information that the radio talk show host says, oh yeah, I know this guy. It's blank Holland. Like, oh, what's his name again? I think it's something like something Holland, but he works at this company and he does this stuff. And, enough information to make it clear and obvious that that's who they're talking about. I believe it's Richard Holland, I think his name. But let's just go with Holland. But it makes it clear that they're talking about Holland. And then after that section of the interview, then the next section is that the radio talk show host says, okay, so are we talking about how gays are bad and straight people are good? And then the head of the agency says, no, that's not true. What it is it's a men-women issue. So what we're talking about is we're saying that single women are actually usually better at raising kids than single men. And that's the distinction that she makes on that radio talk show. So Holland sues. And so Holland sues kind of under a few different grounds. The first thing that he says is, hey, you're discriminating against me based on my gender. You said on this talk show or on this talk show that you didn't give me a kid because I'm a male. So that's not cool. So suing you for discrimination. And he's suing him in federal court under like a federal statute saying, or under the Constitution saying you can't discriminate based on gender. The second thing is that he's saying, hey, you just kind of said that like I was doing a whole bunch soliciting sexual stuff and everything, and that's why you denied me, and you said that on the radio to everyone, and they said my name and stuff, and so everyone now knows or thinks that I'm doing this stuff when I'm not. So you just defamed me. So what the hell? So those are kind of like the two prongs of the lawsuit, and this goes up to the Supreme Court right now, and so there's some kind of technical issues that are happening that encompass the first issue that the Supreme Court is hearing, and then the second issue is kind of a standard on defamation that I'm handling. So the first issue is a jurisdictional situation that was handled in the lower courts that now they're asking the Supreme Court to reconsider. And what that is they're saying, did the lower court make an error when they applied the domestic exception rule to this federal question? So the domestic exception rule is essentially a thing that says when it comes to like, I don't know if you can hear that, but that's the Blue Angels are flying overhead. But so the domestic exception rule is essentially a thing that says when it comes to like marriage, childcare, like kind of like all those things that are like really, really, really close to the family and the home, that's up to the states. That's not up to the federal government. That's up to the states. And so the federal courts, they happily throw that kind of stuff out all the time. They say, no, this is a domestic issue. This is not a federal issue, domestic issue. So, you're done. Sorry. Like, we're not going to hear that. And so the lower court went and applied that and threw out the case and said, nope, sorry. Like, this is a domestic issue. We're not going to hear this because it involves childcare and adopting a kid and all that stuff. And so that's what's happening in this case. The second issue is about whether or not again, Blue Angels. It's about whether or not, like the standard that Holland has to apply in order to sue for defamation, and like the standard that the court should look at defamation. So what this is this is kind of like, there's a standard that was created from a case a long time ago. It was like a New York Times case, New York Times versus someone, I can't remember who. But essentially what it is it establishes the standard for what a court should use when judging defamation, and essentially whether or not a person was defamed is called actual malice. And so actual malice is something that the petitioner, or like the person who's bringing a lawsuit, has to demonstrate the other side did in order to win their defamation lawsuit. And so actual malice is essentially seeing the process of what a publication, usually it's a publication, like what they did prior to publishing that publishing that statement that defames someone. So that means like, did someone either literally say, we know this is not true and we're going to publish it anyway because screw that guy, we don't like him. Or the other side, were they so careless, so insanely recklessly careless, a complete reckless disregard for the truth, that they should in fact be held liable because that was so reckless of them. As it kind of seems, that's actually quite a hard standard to prove. The other standard that it seems like courts are starting to move to in general is that in order to bring about a defamation lawsuit, you kind of have to be a public figure, or you can be a limited purpose public figure. And so a public figure is essentially someone who's a household name. Everybody knows Donald Trump's name. So he can, in fact, bring a defamation lawsuit in certain situations. And there are obviously defenses to that and all that stuff. Everyone knows Barack Obama's name. Everyone knows Arnold Schwarzenegger's name. It's like everyone knows when it comes to like these kind of household names that are so insanely famous that everybody knows them, then that kind of means that they have to use the actual Malice standard. And so it kind of like is a thing that prevents them from bringing about frivolous lawsuits because it's a high standard to make. And when you become a public figure, a public figure that everybody knows and everyone understands, like they do things and stuff, you can debate them. I mean, that's what freedom of speech is all about. And that's what makes it really, really important that this is not just kind of a willy-nilly thing that if you just say, I don't like someone and here's why I don't like them, it would be a bad thing for those public figures to be able to bring about a defamation lawsuit. However, if you are a limited purpose figure, that's someone who kind of like appears on the public stage in a limited way in kind of two ways. The first way is that they have kind of been they've thrust themselves onto the public stage in some limited way. So I don't know, like think about someone who is like on the news or like makes like a thing online or something, and they become famous because of that thing, that one thing. Like say a political commentator is talking about a very, very specific issue, or say like they're fighting for gun control and they're saying, yeah, gun control, yay, do that thing. And then they kind of become famous because of that, but kind of only for gun control. Would it be fair for people to publish things about like that person's marital life or sexual life or something like that? Not really, because that's not really why they're famous. They're only known in that little tiny category. And so the other way is someone is kind of pulled into the public sphere and in a very, very limited way. And so essentially what this means is that this kinds of lower the standards, because that means that the court has to look at essentially a standard which says, were they attacked, were they defamed, were they all this kind of thing in a subject that they have not exposed themselves to the public criticism. So, for example, Holland is a fairly well-known person in his local community in that he was like the chief marketing officer of one of a local company, and he also was kind of at the forefront and kind of the public face of one of the things that they did where they were trying to take a sudden death section off the local bar exam. That's it. That's why he's known. And so he is suing them for defamation, saying that, hey, you were talking about my personal sexual life, and it was not true. And what the hell does that have to do with me, in my job, which is a bar prep class, or me, being the face of trying to take off the sudden death section of the bar exam? That has nothing to do with it. And so because of that, I'm a limited purpose figure, and so I should not be held to the actual Malice standard. What I should be held to is kind of the limited purpose figure kind of a thing. And so those are the two questions. So both of these are super interesting, super in depth, and a really, really interesting things that I have never thought about before. So once again, it's just more learning, more classic law school stuff. Yeah. But anyway, I will see you all later. Have a good weekend, guys.